Good evening, everybody. Welcome to the second episode of Reflections, an initiative of the Bar Library Club, in which we have eminent members of the bar and bench reflecting on their career, reflecting on their journey in the corridors of this court, and in general, reflecting on life. Today, in the second tranche of reflections, we have one of our senior-most members, who's also an eminent lawyer, Mr. Kumar Mitra, senior advocate and barrister. And in conversation with Mr. Mitra, we have Mr. Jayanta, senior advocate. And chairing the session, we have my Lord Honorable Justice Shomen Sen. So, ladies and gentlemen, without further ado, let us first start the session by a few words by Honorable Justice Shomen Sen.
Thank you, Shubhashachi, for giving me this opportunity. This is really I consider it to be a proud privilege and honor for me to chair this session. I first must congratulate the Bar Library Club, the President, Secretary, and the committee members for really organizing this kind of sessions. We really learn from our seniors. They are our idol. So their journey, when they share with us, not necessarily restricted to the chamber juniors, is really a treasure for all of us. I had the opportunity to work in a number of matters with Sri Jayanta Mitra. I have learned many things from him. It's always a pleasure to work with him. And he is possibly one of the seniors who have a very cool temperament. You can very relaxingly attend the conference with him. Maybe you have half read the brief, not the full. But he will not shout at you. He will be very polite in his approach. He will understand immediately when you open your brief and try to brief him that you have not read all the papers. Some papers have been left out. But he will be nice in saying that, Shoman, possibly this page you have not seen, because by that time he has read the brief in the conference. He was an alumni from the presidency, and I was just discussing with him that my Major Mama, Bijon Bandabadhe, was also an alumni from presidency and was the classmate of Dr. Shankar Ghosh, in whose chamber Mr. Mitra was there. He studied in presidency, then he obtained his degree in law with honors from London School of Economics and Political Science in 1962 and was called to the bar from the Honorable Society of Middle Temple in 1963. Then initially he joined the chamber of great legendary late Shubimal Roy, and later on Dr. Shankar Ghosh, another illustrious lawyer of this institution. So this reflection, I think that it's kind of rewind and also look forward both. We rewind to find out that what has happened in the past, where we are at present, and what we expect in the future. They are always a guiding star for us. So with this introduction, may I hand over the mic to Jishnu.
Good evening, friends. Mr. Jayanta Kumar Mitra needs no introduction, at least within these circles. But apart from the fact that we all are familiar with his legal prowess and acumen, there are a few facets to his personality which I think have inspired me in my journey as a lawyer, which I'd like to share with you before I start asking him a few questions about his life at the bar. Because today when we talk about reflections, ultimately the whole idea is that his life will reflect on us present here and to an extent guide and inspire us in our journey, particularly the youngsters who are now in the profession or are entering the profession. I find quite a few faces here. Now, so far as Mr. Mitra is concerned, one thing which is very, very clear is that I have not even till this date, even at his level of seniority, found him underprepared in any matter. As Justice Sen was just reflecting, that there are times when we have gone to his chamber and he has pointed out to us facets of the matter or particular pages of a brief or particular covenants of a contract or particular portions of a statute which had completely escaped our attention. So even at this age, he is absolutely meticulous in his preparation of matters, and that is what I think is one of the things that we take away from him. As I say, that when we are in the presence of our seniors, we almost learn by osmosis, and that is really what happens when you're in the company of people like Mr. Jayanta Kumar Mitra. The second thing which I really have learned from him is integrity in the course of practicing your trade. He is Mr. Advocate's Act, according to me. I have never found him wanting in the matter of giving up a point when he has found that it is not founded on facts, or never found him wanting in his appreciation of the other side when they have come up with something which he has said was perhaps a pivot or a turning point in a matter. The third and most important thing is that I have found him to be a champion of the bar. Just a few days back, Justice Ashim Kumar Banerjee was reflecting on one of these moments. We are talking about many years back when Mr. Mitra was not in his present level of seniority, but he found that in one of the courts, a member of the bar was being rebuked, perhaps wrongly. And he stood up at that point of time and he protested against the treatment of the member of the bar, although he was not a party to the matter. And not so far back, just a few days back in fact, in another courtroom, a young member of the bar was being rebuked because he could not respond to the queries put by court. To which again, Mr. Mitra was not found wanting. He stood up, and although he was not connected with the matter in any way, he stood up and told the court that he is a member of the bar, please treat him as one. And as it turned out, when the court said that he is not being able to respond to the queries from the court, the inquiry from Mr. Mitra was, have you found out how long this gentleman has been practicing? It turned out that he had been enrolled for only 7 days. And that is where we have found him a voice of comfort, a voice of protection, a voice of guidance in all our activities in the bar. He has tackled so many positions together with Elan. He has been a member of the bar library. He has been a member of the profession, a guiding light for the juniors. He has equally managed his roles as president of the Calcutta Club, of the High Court Club, and the list goes on endless. So we will now be seeking to hear from him a few of his reflections in this journey and what he expects from the bar in future, and how seniors like him can be an inspiration for the future generations. So it is a very proud privilege for me to be joining you here in this session in the course of your reflections. So my first question to you would be that, knowing that your family had a background in the profession, your father was a part of the profession, is that why you chose to join the profession, or is it something else that drove you to it?
Well, I was not really made ready for the bar. I was a student of science, and I was quite a good student in that, I was told. After doing my intermediate science from Presidency College, I was destined to be an engineer. I sat for exam in Kharagpur, I sat for exam in Shivpur. I passed in both. But again, I was disqualified in both these institutions because I had very high power. At that time, having bad eyesight was one of the disqualifications to be an engineer. I suppose it is no longer there. So I came back to Presidency College in economics. When I completed my economics course, I was thinking of pursuing my studies in economics. Then my grandfather, who was a professor in Calcutta University, he insisted. He said, no. Your father is a solicitor, then you must be a lawyer. So that is how it started. And during that age, we, the youngsters in the family, had hardly any voice of our own. So I meekly submitted to it. I went to, in fact, I was admitted to LSE for the purpose of pursuing economics, but I changed over to law, and I did my law there. That's how it started. But then again, my father being a solicitor did not inure to my benefit at all. And this is something which I wanted to share with you. I didn't get a single brief from my father, who was a solicitor in the profession. My father's counsel, senior counsel Shubhimal Siroy, then Somnath Chatterjee, then Dipankar Ghosh, then P.K. Dash, and that was it. So the briefs never percolated down to me. I stayed where I was. But I am thankful that I was never briefed from by my father, because I think that stood me in good stead in my future journey.
So, sir, did you have any plan as to how you would approach the profession, or is it something that you just came in and you thought you would learn with the flow or swim with the tide? Many youngsters today don't have that direction. What was your direction when you came into the profession?
Well, I didn't have any particular plan, really. When I came back, in fact, before I landed in Calcutta from England, Mr. Shubhimal Roy told my father that when your son comes back, he should come and join my chamber. I joined his chamber. And his chamber at that point of time, of many others, we had Mr. Suhas Sen, who subsequently became Justice Suhas Sen, Dipankar Ghosh, P.K. Dash, Muthuranath Banerjee, and a few others. In the company of all these counsel, who in future shaped to be the leaders of the bar. So I suppose in course of my journey in the profession, I picked up what I did from these seniors, not necessarily the supreme senior, Mr. Shubhimal Roy, the seniors who were seniors in the chamber also. I picked up a lot of things from them, particularly from Mr. Dipankar Ghosh and Mr. Pradip Dash.
So, sir, you are saying that today it is a lot that has to do with a person's career on the manner he approaches his chamber and the chamber he joins. So do you think that it is very important for today's juniors to also look for and identify seniors' chambers which will ultimately shape their future?
Yes, I think it is very, very important. At least in my life, in my professional career, the chamber practice had stood me in good stead. I must frankly confess that. I tell you how, not necessarily learning the law, but learning the tricks of the trade. I am giving you an instance what happened. There was a big matter going on in court number 2. In that court was sitting Justice A.N. Ray, Ajit Nath Ray, the Chief Justice who subsequently became the Chief Justice of India. A big matter was going on, a very big suit. On one side, I remember, at that point of time, I had just about joined the profession. I was standing in the corner and listening to what was happening. On one side was Shankardas Banerjee, R.C. Dev, Sholil Raichudhuri, Pratibha Banerjee. On the other side was Mr. Shubhimal Roy, who was leading Mr. Siddhartha Shankar Rai, Mr. A.C. Bhabra, Mr. Bulu Ghosh. Now, the case was very strong insofar as Mr. Shubhimal Roy is concerned, that side. Atawal matter, I remember that. And on the other side, Mr. Shankardas Banerjee, so he was the defendant. I thought they didn't have much of a case. Anyway, when the matter was taken up for hearing, after about an hour or so, Justice Ray said, look, Mr. Banerjee is on one side, Mr. Roy is on the other side. This matter should be settled. Go back, talk amongst yourselves, and come back and tell me that the matter has been settled. So matter was adjourned over the weekend, fixed for hearing on Monday. On Sunday, in the morning, I was there because I knew that the conference had been fixed. First entered into the chamber Mr. Bulu Ghosh, smoking a pipe. Then walked in Mr. A.C. Bhabra with a dhoti and shirt. Then Mr. Siddhartha Shankar Rai, in his usual way, with a white short and red t-shirt, they came and sat. There was a very animated discussion amongst them. The junior counsel, meaning there were Siddhartha Shankar Rai and Bulu Ghosh and Mr. Bhabra, they said that we have got a strong case, I'm not going to settle. We are going to get the penny, the last penny we must get it, extract from them. And Mr. Roy was trying to persuade them to agree to some kind of a settlement, give up a part of the interest, don't press for cost, etc., etc. And if they are asking for installment, agree to the installment. The discussion went on for some time. Mr. Roy prevailed. Very reluctantly, the learned juniors agreed that the matter can be settled on site. After they have gone, I was sitting in the corner. Mr. Shubhibol Sirai, you have not many of you have seen him. He said, with a wink in his eye, he said, "Ki bujle." So I said, "Sir, I didn't understand this. You have got a strong case. Why did you want to settle this matter? Why did you persuade your juniors to settle? You shouldn't have settled this matter. You should have fought it out." So he gave a very sweet smile. And he told me, this is one thing I learned. He said, "Listen, Jayanto, if you have got a strong case and there is a possibility of settlement, by all means settle. But you have got a weak case, then you have got nothing to lose. You have to fight with the back against the wall. Fight it till the last." So I asked him, "Why do you say that?" He said, "Remember one thing, that if you have got a strong case, and there may be many a slip between the cup and the lips, if by any chance you lose, maybe because of the fault on the part of the judge, the only person will be blamed is you. But if you fight a bad case and you win at the end, then the laurels will be on your head. So if you have got a good case, settle. If there is a possibility of settlement, an honorable settlement. Bad case, fight it out." This is something I learned. You see, this kind of bits and pieces that I learned in course of my journey, no law book will teach you. No law reports will tell you. But these are the fruits of experience. These gems come and they guide you in your future life. I am giving you another example. There was a matter again in the interlocutory court. I don't remember who was sitting in the interlocutory court at that time. It was an execution application. Small brief, but I was about 3 years in the profession. On the other side was Mr. Shishir Mukherjee and Mrs. Maya Ray. Mr. Shishir Mukherjee became the learned judge of this court afterwards, a very good judge, and a person who used to write excellent judgment. Now there, oh yes, there also Mr. A.N. Ray was there. So when the matter was on, I made my submissions. Judge said, "Take your seat." "Yes, Mr. Mukherjee." Then Mr. Shishir Mukherjee stood up and started making his argument, submissions. Judge was dead against him. And every point that he was raising, Mr. Mukherjee, the learned judge was cutting him down. So it went on for some time. Then a statement was made by Mr. Mukherjee which was not quite according to the record. So I stood up to protest, and I jumped up and said, "My lord, this is not correct." I could feel that somebody from the side pulled my gown and made me sit down. He said, "Fool, sit down, don't talk." So I sat down, and thereafter the judgment was delivered. I won. I came back. I was sitting upstairs. During lunchtime, a small slip was sent to me. Jayanta, come and see me. Mitra, come and see me. A small slip, a bearer from the downstairs bar level club went up and gave it to me. I found it is signed Ellis Meyer. Ellis Meyer is one of the finest advocate that I have come across in my life. I have never seen, never heard a more mellifluous advocate. So I was shivering in my pants. Why is it that I have been called? So I came down. Mr. Ellis Meyer is to sit in that corner table. I came and very surreptitiously sat next to him with his permission. He turned to me and said, Jayanta, I am sorry. I called you name. I didn't even notice what he called me. He said, sir, no, I don't think, sir, he called me. Sir, what is it about? He said, I called you down here to tell you as to why I made you sit down. He said, when the judge is with you, mum is the word. I have never forgotten this. This advice to me from one of the senior most counsel, one of the most brilliant advocate coming to me, I remembered for the rest of my life. When the judge is with you, mum is the word. And then he explained the reason why it is so. Now in the presence of the learned judge, I shall explain to him. He said, and look at the psychology of the thing. He said, Mitra, remember one thing, that the judge who's hearing you has gone from the bar. He had been a counsel at one point of time. And he is sitting over there, hearing all sorts of things. Good argument, bad argument. And his counsel tendency has not died in him. He is still there. So when he is with you and he is expounding the proposition, perhaps much better than you have done, then keep quiet. The reason is this, the judge will feel, look at the psychology of the thing. He said, the judge will feel as he is developing the argument that it is an argument of his argument. It is not your argument. Actually, he has picked up your argument and he is expounding it. But he will feel as if it is his argument. Now, if you interrupt him, he will immediately, the reverie will be completely destroyed. He will come down from the rarefied atmosphere of a counsel to the position. He will think that, oh, yes, it is so this will go against you. So never interrupt a judge when he is speaking on your behalf. And that is why I said that when his judge is with you, mum is the word. You see, these are small things, snippets I am giving you. This is what I learned. These things you will not learn from your books. These things you will not learn from any of the law reports. These are the things which you learn from your chamber, whether it is in your senior's chamber or any other senior's chamber. Therefore, that is why I think, in answer to the question put by Mr. Shah, I think that chamber doing is very important, very, very important. You learn the tricks of the trade only in the chamber.
So I'm very tempted to ask Justice Sen about what his views on the subject are, but I'll keep it for a later time. Tell us a little about what are the hurdles or the disappointments that you faced in the early years of your profession and how you chose to deal with them.
See, the problems in the profession, particularly at the initial stage, I'm sure most of the learned juniors must have learnt it by this time, is that you will find some of your colleagues is advancing much faster than you are. You will find that perhaps in the race which is going on, you are lagging behind. I will say, never get disappointed. Never, never get disappointed. Your motto should be, work hard, be in the court all the time, see what is happening, be in the limelight so that the advocates and the solicitors can see you, can brief you as you grow in the profession. You always must remember that everybody can't start with the same handicap. Some will be advanced, some will be lagging behind. But then again, that should not be any cause. From my experience, I have seen that counsel who had been my contemporaries, who had been my junior perhaps, the counsel who had been my senior also, they had done up to a certain stage much better. But because of whatever may be the reason, maybe because they did not stick to it, you see, some kind of complacency comes in when you start getting briefs. Never allow that to happen. Because then only you start lagging behind. And once you do that, then perhaps it will be difficult to make it up. So never be downcast, never be disheartened, never be upset. Things will ultimately turn out to be good for each one of you. That is my own experience.
So in the course of practicing the profession, was there ever any time when you felt that it was too much hard work and you did not enjoy what you were doing?
Well, thank God that never happened. Yes, too much hard work. I remember I used to come back from Mr. Gaurinath Mitra's chamber after finishing the conferences at 1:30, 2 o'clock in the morning. From Mr. Dipankar Ghosh's chamber, perhaps early morning. I remember on one occasion at Mr. Bholanath Shen's chamber, I was holding a conference. I was called at 10 o'clock. At 10, I went there, waited. 10:30, I was not called. There were other people going into the room. And he was at that point of time a political leader. So after 11:30 or so, I didn't know when I will be called. So I put the briefs on the sofa, I lay flat on my back and went off to sleep in his chamber. At about 1:30 in the morning, Mr. Sen Biara came to me and said, "Sir, now your time has come." So rubbing my eyes, I walked into the chamber. "Oh, I am so sorry, Jayanta, I kept you waiting this long." Lo and behold, at around 2 o'clock in the morning, a phone call came. My mother. See what is happening? 2 o'clock in the morning, how is he going to come back? So she was very stiff in her language and said, "How is he?" I said, "Bodhi, don't worry, I shall drop him." At 2:30 in the morning, after finishing the conference, he drove down his car, took the car out of the garage, drove me down to my house. So this is what the hard work meant at that point of time. I never grudged it, I never felt sorry for it, and I am very grateful that I had been given the opportunity and I had the physical strength to withstand this kind of hard work.
On a little different topic, we have in our profession, different, like in music, different gharanas. Suppose a particular junior belongs to a particular senior's chamber, and the tradition develops in that way. So how, Mr. Mitra, will distinguish your school or your teachings that you have learned from the other set of the chambers, your contemporaries?
This is a very important question for all of us to consider and answer. You see, when I joined the profession, one thing struck me as very significant about this profession. And it is this, that this is the only profession, I think, which is called a noble profession. No other profession, whether it is medicine, chartered accountancy, or any other profession, nobody calls it a noble profession. So it made me think, why is it that legal profession is called a noble profession? Why is it that you address your adversary as my learned friend? Why is it that you address the person who is sitting up there as either my lord or the honorable judge or your honor? Why is it? The only answer is this, that this is a profession which enables two sides to come directly in conflict with each other. And this is the profession, and only profession perhaps, where you never get into fisticuffs. You sort out your problem on the basis of your argument, on the basis of your submission. You sort out your disputes on the basis of your argument and counter-argument, submissions and counter-submissions. And you leave it to the learned judge to assess as to who has put forward the better points of law or facts, and then decide the issue. So I always kept that in mind, that it's a noble profession, you treat it as such. Don't quarrel in court. Keep your cool. Never be abrasive. Never be quarrelsome. Nowadays I see, very rarely of course, one or two incidents which had happened in court, which perhaps is not very acceptable to the profession of ours, where the counsel had been vitriolic, abusive to the other side. This is not this profession is for. People say that I am very cool in my temperament. No, I may not be so. My wife doesn't think so. Anyway, but then again, why is it that I keep my cool? Because this is the profession where you should not do anything which will cause annoyance to the court, which will cause any hurt, any feelings of distress to the other side. After all, you are saying my learned friend. So this is a noble profession, you treat it as such. Be very polite to the other side. Be very polite to the witness. Be kind to your client and be considerate to the court. Then only you will be able to achieve what you are seeking to achieve in this profession.
So, taking off on your last answer, when you talked about this profession being a noble profession, I'm sure that there have been times when you have been disappointed with judgments which you have thought should have gone the other way. I'm sure there are times that you felt unhappy with the attitude of the court or an arbitrator against you. And I'm sure that you have felt the need at times to vent in these circumstances. So how did you tackle these situations?
Yes, I cannot say that I didn't feel disappointed occasionally. I cannot say I didn't feel upset on occasions. But every time when I came out of the courtroom, I took my gown off and gave it one or two jerking so as to remove all my ill feelings, all my disappointment out. After all, it's a matter which has gone against me. If my client thinks that no, this is not the order, a judgment should have been passed, there is a court of appeal. Go to the court of appeal. Always remember that everything in life does not go in the way that you would like it to go. If you remember that, I'm sure there will be no disappointment on your part.
Just picking up on the same thread, we are talking about disappointments when judgments have been delivered as you expected them not to be. But what would we advise to the new generation or the younger generation about how to deal with difficult judges or difficult arbitrators?
If the judges are difficult, then it is your duty to make him not difficult. I give you another instance, what happened. These are all bits and pieces that I have learned in my journey through this extremely interesting profession. This was the court of Mrs. Binayak Banerjee. He was supposed to be a very tough judge and extremely voluble and used to shout at the council. In one matter, I was not briefed in that matter. I was in the chamber of Mr. Shankar Ghosh, courtroom number 11. I remember the courtroom also. The solicitor was Mr. Lalit Banerjee. You have not seen him. He has no longer in the world of the living. The council were briefed in the matter for the respondent, for the petitioner. It was Dr. Shankar Ghosh, Mr. S.B. Mukherjee, Jolu Mukherjee, and there was nobody else. What I used to do is in the chamber, I used to go in the evening, I used to read up the brief for the next day of Dr. Shankar Ghosh. So this was one of the briefs. I remember it was regarding an oil company and acquisition proceedings. I went through the brief. I hardly understood the points of law. I made a list of dates, just for my own sake. And then I was there, sitting there, just waiting in the courtroom to see how the things will be argued. On the other side was Mr. Bonamali Das and Mr. Mrigen Sen for the state of West Bengal. They were arguing, I was sitting at the corner and listening to them. No sign of Mr. Ghosh, no sign of Mr. S.B. Mukherjee. I was expecting that they would come and soon join. The argument of Mr. Bonamali Das was over. There was no sign of either the senior or the junior. Mr. Lalit Banerjee said, Jayanto, ask for a Passover or not today. So I stood up, with the trembling legs. I said, my lord, kindly my lord, make it not today. Not today? And he screamed, this is a contempt of court. The matter has been heard for such a long time and you are asked for today. You have the cheek to do so. And it was a very strong languages they were used. So I said, my lord, then pass it over. Again, pass it over. Again shouting. So I said, come what may, let me start. So I said, may I then argue? Yes, you do it. So I went on, I had a list of dates. So I went on arguing on the basis of whatever facts was known to me. For 35 minutes I held on in that court. And I was sweating profusely. At the end of about 35 minutes, Dr. Ghosh rushed in. And then followed by Mr. Mukherjee. So Dr. Ghosh came in and said, my lord, may I take over? You take your seat, Dr. Ghosh. Let me see how long it takes to break your junior down. This was the statement. And then he went on playing around with me. Now, after some time, then of course, the judge was kind enough to say, you take your seat, Dr. Ghosh take over. The matter, they lost. So after the thing was over, I came out of the courtroom. So I was in shaking, absolutely, in nervousness. But the solicitor was very happy. He said that you have saved the day for me. I tell you what, that was one of the very first exposure that I had in a court of law, in front of a very senior judge and a very voluble judge. But I never turned back. From that day onwards, that court was my court. Whichever matter I did thereafter in that court, the court, bent backwards for the purpose of giving me relief in whatever way it was possible. This I say for the purpose of encouraging the juniors. Don't be downcast. Don't be disheartened. If the judge is rude with you, always remember that there is nothing personal in the judge. Insofar as you are concerned, he is just testing how good you are and how long you can withstand. This is a profession to be able to withstand. If you can withstand, then you succeed. And that is my experience.
So thank you so much for these encouraging words. I think that is a very important lesson that all juniors need to learn. But there are judges who are equally rude to everyone, so they use Article 14 in that regard. And there are judges who are selectively rude, so that would make a difference, I suppose. Now, so far as the profession is concerned, like all of us, I'm sure you came into the profession with a lot of ideals, with models that were not really stretchable at that moment. In the course of practicing the profession, did you ever feel the need to compromise with what your established norms or ideals of practicing the trade was?
No, I never had the feeling of, I never had the occasion to do that. As I said, this is a profession, unique profession. And you must always feel that you are one of the privileged persons who we will have the opportunity of serving people. Do not take this as a profession only. This is a vocation which enables you to serve people. You see, I tell you what, I've jotted it down. This is how I felt throughout my life in this profession. Now I have put in almost 60 years in practice. I firmly believed always, you see, I saw the independence coming in. That was in 1947. I was about 8 years old. I don't remember anything about it. But in 1951, when the Constitution was taken, there was, in our mind, there was a feeling of elation. I could feel the elation, the feeling of well-being that was felt by the people of this country, and I was a part of it. I firmly believe in the rule of law. And I also believe that the rule of law can't be built on the ruins of democracy. I always try to remember that the central function of legal profession, and this is very important, I'm telling you how I felt all through. I always try to remember that the central function of the legal profession is to promote administration of justice, and that the integral part, bond between the lawyer and the public, integral bond between the lawyer and the public is the very foundation of the principle of the rule of law, on which a democratic republic like ours is built. I always kept in mind that the vital role of a lawyer depends upon his probity and his professional lifestyle. Do not forget that you are the person who are to be emulated by the society. People in the society will look up to you. And that is why I say the vital role of a lawyer depends upon his probity and his professional lifestyle. I believe that the practice of law is a public utility of great implications. A lawyer should always remember that he is rendering public service by being a ministerial of administration of justice. Never forget that monopoly has been statutorily granted to you. This I am quoting from a judgment. It's been statutorily granted to the advocates of the nation, which obligates a lawyer to observe scrupulously those norms which make him worthy of the confidence reposed by the community in him as a vehicle of social justice. I firmly believe in one thing, that today, if you carry out your duty of serving social justice, then it is the society which will come to you, look up to you, and commend you for whatever you have done for the society. I do not feel that it is only a profession. This is not only a profession for the purpose of earning money. You will be getting briefs from teachers in a village. You will be getting briefs from a bank clerk. You will be getting briefs from an indigent father whose son had been neglecting him, you will not be able to charge fees for them. You won't have the guts to do that. You won't have the heart to do that. You will do it freely. Why? Because you feel, in your mind, over the years will be inculcated the feeling that I am doing social justice. This is something which I am doing not only for the purpose of earning money. I shall render free service to the people. You do that. When you do that, you come back, you feel that you have earned much more than the money which would have gone into your pocket. I feel this is what a lawyer should learn.
So these are very, very inspiring words, sir. And I wish that all of us present in this room and those who are watching you over the virtual medium and will be watching you over the years to come really draw inspiration from this. We very often forget that we are actually rendering social service also, and we are unfortunately at times only striving to earn money. This is a lesson for all of us, which I hope we have learnt well today. So I have also heard you say on many occasions that in the course of practicing your profession, you have learned from your seniors as also from your juniors who have been working with you. So to what extent do you feel the need to encourage the juniors to come out and speak out on their own, even when they have a conflicting view with yours in the course of conferences?
In answer to the question, I shall only say this, that when you have received the brief from your client, you are to espouse the cause of your client without misleading the court. You try and find out what are the best facts which you can extricate for your client. You must remember one thing, all cases cannot be good for you. There may be good cases, there may be bad cases. But then again, you try and get the best that you can do from whatever facts are available without misleading the court. Remember one thing, that if you mislead the court, if there is any way you have ever misled the court will never believe you. You must have the confidence of the court. The court, I remember Mr. Shobhoshaji Mukherjee, before whom when some counsel is to argue, he never used to open his brief. He used to believe every word of what the counsel used to say. This is the confidence a counsel is expected to earn from the court. When the court will say that this counsel is saying something which cannot be wrong. If it is found out to be wrong, if it is found out to be misleading, then you lose that court for all times to come. Be firm, adhere to the principle that you'll have to do whatever justice is possible for your client. But also remember that you cannot turn a bad case into a good case. You can try and get the best out of a particular case, the best that you can get. But never think that for the purpose of making my client win, I shall bend backwards. No, don't do that. Do the best that you can do on the basis of whatever facts are available.
One thing I'm really curious to know from you, sir, is what would be your advice to the junior members of the bar to improve their drafting skill and advocacy?
Listen, drafting depends upon the amount of practice that you have put in. I mean, in the sense, when I say the amount of practice, I mean the amount of work that you have done. You'll have to know the law and you'll have to know the facts. And drafting will be based upon that. I remember one of the best draftsmen I have seen in my life, is Mr. Omya Kumar Basu, whose photograph you see over there. He used to draft plain 1.5 page, 2 pages. Absolutely model drafting. You know why it used to be so good, and you could not find any fault in them. The reason was that he, first of all, after he used to get the case, he told me this himself. After he used to get the case, he used to look into the facts, analyze the facts. Then he used to look into the law, how to fit the law onto the facts. And on the basis of that, he used to draft. And his drafting was so meticulous that it was very difficult to find faults with them. Now, I will suggest, and it's very difficult, I mean, to become like Omya Kumar Basu, I mean, it's very difficult. I remember Mr. Shankar Ghosh once told me that there was a contempt application moved. He said, go and get hold of the draft that Mr. Omya Kumar Basu has made in respect to the contempt application, I think, of Subodh Banerjee, who was the food minister. And there was a contempt application there long time back before Mr. Justice Dotto, Sushil Dotto, in courtroom number 5. That was a model piece of contempt application. Now, you see, this cannot be taught. I cannot teach you as to how to draft. Drafting is something which will depend upon your command over the language and your command over the law and facts. So if you study well, then I am sure that your drafting will also be well. But one thing I shall say is this, that when you draft a thing, you do not be verbose or do not be, what should I say, prolix. Our drafting, you see, there is a difference in drafting in Calcutta High Court from Bombay High Court and Delhi High Court. There I have found that in drafting a plaint, also evidence is pleaded. We have not learned that in our High Court. We have learned to draft, when you draft it, you draft in the way that the basic facts are given. If it is necessary, give the principles of law which will sustain those facts for the purpose of being successful, and nothing more, nothing less. But then again, drafting differs from place to place. It is totally different from one to other. I remember I have seen a Delhi plaint with evidence and everything. It was about 50 or 60 pages. And if it had been drafted in Calcutta, perhaps it would have been 15 pages. So this is something which you will have to learn as you go along. And drafting is a thing which you have to practice all through. I mean, there is no end of it. I remember there's a story I'm telling you. These are all experiences that I had drafted a plaint. That was when I was 15 years old, or 15 years in the practice. And that was to be settled by Mr. Ashok Sen, who was in Delhi. So I went to Delhi to have the plaint settled. Khaitan and Company was my advocate on record. I sat there. There were conferences. Mr. Sen told me, Jayanto, wait for some time. Let me finish off these conferences, then I shall settle. So after the thing was over, he sat down with my plaint. And he started reading, and as he was going on, I was sitting on the opposite side. Bah, besh likecho, bah, besh likecho. And he went on saying so and correcting. After the corrections were over and the thing was finished, nothing was left of my plaint. The whole thing was read. He corrected the whole thing. But throughout he went on saying, bah, besh likecho, besh likecho. Now the point is this, I do not know whether I besh likechi or besh likini, but the encouragement was there. And when he drafted the plaint, I knew how it is to be drafted. It was a beautiful piece of artwork, I can tell you this.
So I can see Mr. Chaudhary looking at his watch. So I think we'll have to round it up. But just one last word of advice to the juniors here and to most of us present, of course.
I will only suggest this, that when you are, you see, I tell you very frankly, nowadays I find the juniors are much cleverer, much more intelligent than what I was at their stage. They know law, they study the facts, they come to the chamber, with confidence they speak. I personally feel very encouraged. I feel that they've got very bright future. Of course, they don't have to remember so much as we used to do in our younger days, because they have got the computer in their hand and WhatsApp and whatnot. But then again, I find that they are very extremely intelligent, extremely industrious, and they are clever. They know exactly what they are talking about. They need some guidance, and we as seniors, we do give them guidance from time to time. But one thing I can tell you this much, that when you are appearing in court, you choose the way you want to proceed. Do not be boring to the court. Do not go on sort of rambling. You know that you know more than the judge does, because at that point of time the judge has not really had gone into the matter. So you are explaining to the judge. But for heaven's sake, don't be boring. Because I remember Mr. Shobhushaji Mukherjee, when he used to get bored, he used to read the list, the daily list. I don't know how many times in a day he had gone through the list. Because whenever he used to get bored, either he used to go and he used to look through the window toward the Ganges, or he used to read the list. So I will suggest that don't be boring, be precise, and try and see how the judge is thinking. The learned judges, you will have to convince the man who is sitting over there. So you will have to study all the time how he is reacting. If you find that particular point is not being accepted, kindly excuse me, learned judge. When you find the learned judge is not accepting a particular point, do not go on rubbing on that. What you do is this, you very smoothly move on to the next point, which may be acceptable to the court. So you harp on that point. When you find the judge is in your favor, you go back to the point which was not being accepted by the judge. You will find the judge will be more inclined to accept the point which he was not accepting earlier. These are small tidbits which we have learned. You know who had taught me? Mr. Gautam Chakraborty. He is a superfine advocate. He used to do this thing that when he used to find the learned judge to be not accepting a particular point, he used to move on to the next point and come back to the earlier point after 1 or 2 points or thereafter. And he used to convince the judge. Now, I just want to finish this. This is what I read from on the issue of being boring before the judge. This is what I read from Mr. Fali Nariman's latest book, Beyond the Courtroom. I'm sure that many of you have read it. He has written this. In an American courtroom, the judge, apparently bored by the counsel's argument, has gone to sleep. The counsel leaned forward and told the court clerk, "Charlie, wake him up." And Charlie cheekily responded, "You wake him up, since you put him to sleep in the first place." Now, I will suggest that don't do anything which will put the learned judge into sleep, number one, and you'll have to tell the court clerk that wake him up. No, never do that, never do that.
We had an excellent conversation with Sri Jayanta Kumar Mitra. It's reflection as well as revelation. It's a matter of understanding. Strong message has been sent to the juniors with encouragement, I would say. Whatever his experience he has shared with us, I think we'll ponder over it, we'll take the best out of it, and we'll try to follow his advice. These advice are freely given, so don't take it that you can ignore it. But these are invaluable advice to the members of the bar. I thank Shobhushaji and the committee members, the President Secretary, for giving me this opportunity, for inviting me. I wish Sri Mitra a long, peaceful, happy life. Thank you, Mr. Mitra.
Thank you, Jayanta.
Thank you.
sir.
I thank the organizers for having given me an opportunity to interact with all of you. And it was a pleasure. And it was a learning experience also for me. Thank you.
Thank you, Mr. Mitra. Thank you, Justice Sen. Thank you, Mr. Shah. And before we wind up today's proceedings, may I invite our President, Mr. Sudipto Sarkar, to come up and say a few words.
Justice Sen, Mr. Mitra, Mr. Shah, colleagues of the bar, good evening. May I add a rider to Mr. Mitra's reflections before I say anything more? When I first came to the High Court, I was not eligible to practice. I was not eligible to even to be a member of this club. But in the hope that someday I will be, I was put in the chambers of Mr. Shankar Ghosh by Mr. Bonamani Das, who was a family friend. I turned up there one evening and found who I now know to be Mr. Mitra sitting in the side room, Mr. Ghosh sitting in the large room behind his desk. So we had a little conversation. Mr. Ghosh said, keep on coming here. Then he took me and introduced me to Mr. Mitra. He said, Mr. Mitra will look after you, because Mr. Ghosh was very reserved sort of person. He was friendly, but somehow he kept to himself. He didn't like too much conversation. From that day onwards, I kept on chatting up Mr. Mitra for any bits or pieces that I could gather from him to learn more about the High Court. And he was, of course, very helpful. And after a few months, I did become eligible to practice. I did become eligible member of the library, but I had no transport. So what do I do? So I told Mr. Mitra. He said, don't worry. I will pick you up every day on my way to court, and I'll drop you back. And this is what he did. For as long as I can remember, and I shall ever be grateful for him, I used to stand on the road, and he always used to pick me up in a standard 10, if I didn't believe in those days, a white and sort of blue, green, white and green combination. And these are things which all juniors must remember. This is what this library is all about. Helping, juniors, helping one another. And in the evening, there used to be a carpool. And I was one of the members who was put in the carpool. Fortunately, there was one vacancy. There were one or two others. Mr. Deepak Basu used to go to drop him, then Mr. Mitra will drop me, and then go on. So these are things, gentlemen, you should remember. You heard Mr. Mitra, whatever you have heard from him, but please remember that so far as juniors and seniors are concerned, the help I got from him, of course, Mr. Shankar Ghosh, of course, helped us a lot, but as Mr. Mitra said, you have to read his brief and see next day what he is doing, because he didn't like discussing his matters and cases and all with others. Whatever conference he did. And thank you, ladies and gentlemen. I think it was a very preventful evening. You've learned a lot from Mr. Mitra. Thank you very much indeed.
With that, we come to the end of today's proceedings. The third tranche of reflections we will notify you soon.